Wait. So that's his.
Yeah. Clear.
Mr. Bester, do you have anything to say? Mr. Bester, it's Crisalda from SABC TV. Do you have anything to say? Mr. Bester, do you have anything to say? Mr. Bester? Mr. Bester?
The magistrate is entering in 5 minutes, eh? All photos, please take your position.
Stay on the little
Yes.
You still on our visuals, right? Okay. I don't have a mic. Okay, okay, and then copy your come to me, right? Okay. I'm going to be on the camera mic. Copy, stabilize.
Chris, you are live on him. Can you hear what it means?
Are you feeling? These are live pictures inside the Bloemfontein Magistrate Court. And you can see Thabo Bester has entered the courtroom. We're expecting proceedings.
Can we get seated, please? The magistrate is on his way.
Get underway any moment. Now we've been asked to be seated as the magistrate will enter in the next few moments. Here, Thabo Bester has taken the dock. Right? We're being asked at this point to be or we're being asked to be seated at this particular point as proceedings are about to get underway. Thabo Bester has arrived inside the courtroom, and so has the judge.
As a place, just a moment to allow the setup now. And the court is now in session. There can be no pictures.
May I direct that there be no movement at this time, please?
Yes, please, record Joseph. Case number is 28/113, 2023, State against Thabo Bester. Joseph, the accused is appearing for the first time before you. The state applies in terms of section 157. Then he be added as accused number 5 in the matter. The court shall note that accused 1, 2, 3, and 4 already appeared before this court, and may he be added. I will then address the court further.
Right. May I firstly establish, is the accused having a legal representative?
Judge, Mr. Kapil informs me that he has instructions to appear for the accused. As please.
Mr. Karpe, the public prosecutor brings an application for the joinder of accused in terms of the provisions of section 157, subsection 1 of the Criminal Procedure Act 51 of 1977. Is there any objection on that?
Your Worship, at this stage there is no objection. We had already deliberated with the state. As far as that is concerned, I also have no instruction as to object.
Thank you, sir. The application brought by the public prosecutor is hereby granted. The accused is hereby duly joined to this case under case number 20/113/2023.
Joseph, just before we move on, the accused is before you on the strength of a J50 warrant of arrest. He was then re-arrested. On the basis of that warrant of arrest, may the state apply that it also be cancelled. In fact, it be cancelled.
You may stand up, sir. A warrant of arrest that was issued against you in the form of J50 is hereby cancelled. Thank you, State.
As I indicated earlier, the matters against accused 1, 2, 3, and 4 is already postponed until the 17th of April for the purpose of bail information in relation to those 4 accused. In the case of the accused before court, I want to place it on record that he is already a sentenced person, and there is therefore no need for postponement in terms of simply for bail information. On that basis, Your Worship, the state wishes to apply that the matter against him not to be postponed until the 17th, but rather be postponed for a period of a month for purpose of police investigations. That will also be taking care of some security concerns if the accused has to appear in 2 or 3 days' time, only to be with the rest of the accused. They will be together in any case at some stage of this hearing, but for the purpose of bail information, his attendance is not needed on Monday. So the state brings an application that it be postponed for a period of at least a month. as it pleases.
Thank you. Mr. Kapper.
Court pleases, Your Worship, before I address the court, I just got a call from the accused. May I please turn to the accused?
You may do so.
I thank you for the indulgence. Your Worship, we have heard both states' applications, which are somewhat contradictory, and I'm coming to my instruction. The one application is to join this case to the other cases. At the same time, there's an application to separate the two cases. Hence, my expression to say both applications are somewhat contradictory, but nonetheless, there is no objection to any of the state's applications. However, my instruction at this point is to request that the postponement be shorter than a month. If it's the reasons provided from the state is for further police investigations. The court, I think, will agree this is a rather peculiar matter, hence the nature of the application, other applications, and hence the nature of our request. But nonetheless, this is an accused like any other accused who is entitled to a speedy trial. My instruction is merely to request a shorter period for Mr. Bester's postponement.
Audi Altaram Partem, I want to talk on behalf of the state. Is there any response? Allegations, one, contradictions.
We've passed the stage where he has already been joined. There was no objection. I don't see how my learned friends still bring that, because the court already made the ruling. That's number one. The state's application is by no means separation. We're not separating. It's already added there. The state's application that it be postponed for a month is for the purpose of the bail application. Your Worship, the court should bear in mind that on Monday there's a possibility that that matter on Monday in respect of 1, 2, 3, and 4 will once again be postponed for a shorter period until the bail is completed, which might take quite longer. I cannot understand the reasoning for a shorter postponement that my learned friend is talking about when, Your Worship, I need to place on record, he has already been sentenced for life. In terms of bringing a speedily trial, yes. But the fact of the matter is, Your Worship, the investigations are so extensive and so broad that within a month the investigation will not be done. That I can confirm and guarantee. And I'm saying there are concerns in terms of security, and the matter will ultimately, after the investigations, there is already a decision by the Office of the Director of Public Prosecutions that the matter will be ultimately be heard in the High Court. That can never take a period of a month. That is my submission. As it pleases the court.
Thank you.
On that note, yes, maybe I should also at this stage hand in and submit the decision from the Director of Public Prosecution that is dated the 13th of April 2023, And I want to invite the court's attention specifically to paragraph 2, where it reads, the trial will commence in the High Court. Just for record purposes.
There's a confusion. Bishop, we have recently had sight to this document, the DPP decision. We have no objection that it's handed out. However, we would wish to be first by the state with a copy.
The document purported to be a decision from the Office of the Director of Public Prosecutions is hereby received by this court and is marked as Exhibit A.
As it pleases.
Confusion. Again, permission to approach.
You may approach.
Again, I thank you for the indulgence.
Yes, Mr. Papi.
Your Worship, I had also received instructions earlier. I just confirmed it again now. Your Worship, the accused is at this stage legally represented. However, as indicated, this is a rather peculiar case. The accused would wish to address the court with at least 2 points, which are of concern. Hence, I'm bringing a formal application. However, it is from the party that he be given an opportunity to address the court, notwithstanding him being legally represented.
You're not able to convey the scene through.
No.
Can't you take instructions and address the court?
I can, Your Worship, however.
Yes, you are the mouthpiece of the accused when you are in court.
Indeed, sir.
Yes. You may take instructions, then address the court on that aspect.
As a conclusion.
Yes.
Thank you for the indulgence, Your Worship. Your Worship, on the very same note that the state raises safety concerns, my client, the accused, Mr. Bester, also has safety concerns of his own. I have no one to say for obvious reasons. So let me go ahead and divulge the reasons. This accused is in the custody of the very same institution that the alleged escape occurred. That on its own is the reason for concern of the accused safety. My instruction earlier is that the accused hasn't eaten since he was incarcerated. He is afraid to eat the food provided by these very same institutions. The accused also requested that at least today, because we are still going to consult further after this postponement, that he be provided food, preferably by this legal team which he has entrusted to represent him. Further arrangements will be made. However, I just need to bring it to the court's attention that the accused has raised concerns for his safety. The accused would also wish to be furnished with the extradition documents of how he was brought to South Africa. According to the accused person, he does not have the ID number. Therefore,
can you repeat yourself? According to him, he does not have.
You see, Your Worship, that is why the accused had requested that he address the court himself.
No, I could not hear you. Yes, you say accused doesn't have. Did you say ID number?
Or rather, he does not agree with the ID number in the temporary passport. Therefore, he would wish to be furnished with all those travel documents. Your Worship, you did indicate I am a mouthpiece. I'm merely conveying the accused's concerns. Well, my immediate concern as his legal representative is the first issue raised regarding his safety. Regarding the dates, I will say we are in the court's hands. We have made our submissions. The state has also made its submissions. We are in the court's hands, but those concerns I have conveyed in instructions from the accused person.
Having those concerns, is there any alternative that the defense is having?
Today's alternative, I had already placed it on record. The defense team can, at least for today's purposes, and I did say there will be further arrangements made.
No, I'm saying alternative, specifically dealing with the issue of safety as part of his concern.
Your Worship, the accused just indicated. May I just turn my back?
Yes. But before that,
yes, indeed, Your Worship. Indeed, Your Worship. I'm rather surprised by these submissions on the basis that, and I want to place it on record, that before his appearance today and before the alleged escape, which forms part of the charges before him, before court today, he has been in the very same institution, correctional service, for a period of about 8 years or so. And he was fed for those duration, the duration of 8 years plus. He was in the hands of the correctional services. And Your Worship, like I'm saying, once the person is now a sentenced prisoner, the responsibility shifts from this honorable court to the constitutional institution with the responsibility of caring for such a person. This court cannot interfere with that. This court cannot order that he be treated differently from any other. I understand it's a security concern, it's a safety concern, the same that the state is saying there is a safety concern. If my learned friend has issues, those issues need to be addressed with the correctional services and whatever arrangements be made with those with the correctional services. He is now the responsibility. The burden is now on the correctional services, and it is not for this court to entertain that. Extradition involves from one country to the other. When he was moved at that stage, specifically in this instance from Tanzania, that is where he should have articulated his concerns about the ID numbers and there. Not now here. Here he is correctly before this court through a J50 warrant of arrest, which has now been cancelled. The warrant of arrest, when he was arrested, it does not involve, it had nothing to do with extradition. We should separate issues. We should not just contaminate this court with lots of other issues that has actually nothing to do with the matters before court, the charges before court now. That is my submission. That he does not agree with the ID number, he must take that up with the Home Affairs. It's not for this court to then say, okay, here is your correct ID number then. It's an issue for Home Affairs. That is my submission before this honorable court. Let's separate issues and let's address them with the correct, relevant institutions, as it pleases.
Thank you, Mr. Kapira.
As a conclusion, Bishop the charge, I believe one of them is statements. Extradition was one of the mechanisms used to get this court.
Yes. To interject. In short, the public prosecutor says this court has got no local standard to entertain those issues that you have raised. Can you dispute?
Your Worship, I was in the process of replying to a state, particularly as far as it deals with relevance, that these issues are not relevant.
Yeah, but if you can address the question whether do I have a local standard to entertain those issues? Because if I don't have local standard, then redundant to deal with those aspects that you have dealt with. The issue is whether do I have a local standard.
Your Worship, with all those, can I leave that in the court's hands? Mine is to just make a submit my arguments on behalf of them. Whether this court has local standing, does the state's argument. I cannot now say this court does or does not.
In simple terms, I cannot authorize the correctional services to say to them, keep the accused at a particular place. I do not have that authority over them.
We did say this is a very peculiar case, Bishop. The concerns raised by the accused, particularly the safety issue, is not a frivolous concern. I will, with all due respect, that's a very genuine concern that this accused is raising.
Yes.
Also, the fact that he hasn't eaten for more than 24 hours, well, that's none of the court's interest. However, the safety issue, and I did say further arrangements will be made. I'm not saying this court make rulings regarding what arrangements to be made, but I will say I will be guided by this court, having heard the submissions made on behalf of the accused person.
Yes, as I understand, there is no dispute about issues raised. They are genuine issues. No one is denying that. But the issue is they must be addressed to the relevant institutions or relevant authorities, not this court. Thank you. Yeah, the date.
As the state suggests the 16th day of May 2023.
That was 16th day of May for investigations.
Your Worship, I do apologize. I think I turned without seek permission. The 16th is to Worship.
And then,
16th of May.
yes, the only thing that I know is that accused is in custody, sentenced prisoner. I'm not sure as to the side of the defense. Is he abandoning his right to apply? I'm just asking for the sake of my record to reflect properly.
There is also a genuine concern from the court. I'm sorry for the up and down. May I just have the accused?
Yes. Thank you.
Thank you for the indulgence of the Bishop. My instruction is that at this stage, the accused is abandoning bail. However, he does reserve his right to bring a bail application at an appropriate time.
Mr. Bester, you may rise up. Sir, your case is remanded until the 16th day of May 2023. Same court number 20A for investigations. You are in custody, bail abandoned. Thank you.
Yes, that concludes my role for you.
Wait. Court is still in session. I have directed no movement during these proceedings.
Yes, can I then ask that while the court is still in session, at least only Mr. Bester and those that accompany first move out before the court completely adjourns?
Yes.
Because I'm afraid it's going to be. Thank you, Worship. We may now adjourn. Fine. I did not consider a diary. We shall have to make special arrangements. Oh, my role is complete. Yours still continues. Thank you very much, Yoshi, for the indulgence. Thank you. Yeah?
Wat gebeurde G7?
Man is gonna be happy to get our jobs.
Go off its line.
Thank you, Annette.
Didn't you take one?
Everything.
Okay, no problem. Thanks, Chief.
Yeah,